Hey everybody, John Skiba here, and in this video I'm going to talk about original creditor lawsuits that are brought by Capital One. This is second in a three-part series that I'm doing on how to deal with original creditor lawsuits as opposed to junk debt buyer lawsuits that we deal with so much here on this YouTube channel. But if this is your first time here to my YouTube channel, please click subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, let's talk about Capital One and original creditor lawsuits, in particular. Capital One is one of the few creditors that typically does not sell their debt. The last video I did was on American Express. They never sell their debt. They bring the lawsuits on their own, they hire these outside attorneys, and then they sue. Capital One sometimes sells their debt. Most of the time they don't. They'll bring the lawsuits on their own, but you will see them sell, particularly HSBC credit cards that they have connections to. A lot of those end up with Portfolio Recovery Associates, one of the larger junk debt buyers throughout the country. So the approach, though, that I recommend that people take when you get sued by an original creditor like Capital One is more of a settlement strategy rather than a litigation strategy. Now, one question a lot of people ask me is, how do I know if it's the original creditor or a junk debt buyer? The easiest way is just to look at the complaint and the summons. The top of the first page is called the caption. Now, a lot of people get confused because they look at the caption where it has like the plaintiff and defendant, and it'll have their name and then your name. But in the upper left-hand corner, they'll also see the name of a law firm. The law firm is typically not the one who owns the debt. Like the Gerstel law firm is a firm here in Arizona who does tons of collections. They do a ton of collections in Minnesota. They're a big debt collection firm. They are just lawyers. They're just hired guns that are being hired by the plaintiff in the case to try to get a judgment. They don't have any ownership interest. So sometimes people will come to me and the plaintiff, it'll say Capital One versus John Skiba. But people will get confused and think that no, Gerstel's claiming ownership, and so they'll try to use some of the junk debt buyer defenses. That's not the way you want to go. If the plaintiff itself is Capital One, American Express, or whoever the credit card company is that you actually took the card out with, that's an original creditor suit. And when you're dealing with original creditor suits, like I said, I typically recommend a settlement strategy rather than a litigation strategy. The reason is many of the defenses that you have against junk debt buyers like Midland Funding, Unifund, Calvary, Portfolio, they have to prove several layers. They have to prove you had the original account. They have to prove that they transferred it where they struggle to do that. They have to prove the amount owed, which they can struggle with at times. And then not only that, when they get into a trial type setting, they're not going to have as many of the documents. They're for sure not going to have a witness from the original creditor. They don't have any of that. And so it's more easy to put forward some of those defenses. Original creditors, you're going to assume they have the documents and the employees because they all work there. If they don't, there's a much bigger problem. If they've lost all the documents or if they don't have your payment history, it's highly unlikely that that's going to happen. And so what I see is a lot of people, they'll try to push these things to trial and try to tell the court maybe why they fell into default or explain that there's been, job loss or disability or divorce or something. Those generally aren't strong defenses. The court's really just there to see if you're liable for it. And an original creditor like Capital One is going to be able to prove that. And if they win at trial, they're likely going to be able to add attorney's fees and court costs on top of it. So if you're getting sued for $5,000, that could end up being $7,000 or $8,000 or $9,000, depending on how much attorney's fees and costs the court awards them. So that's why I generally recommend a settlement approach. And really, there's two approaches to take. There's either a lump sum, where you come in with some type of offer fairly quickly. With an original creditor, the settlements are higher as well because they're in a better negotiating position than a debt buyer is. So they usually settle somewhere between 40 to 60% of the total amount owed on the amount that they're suing for. Or you can enter into a long-term payment plan. Most of them will offer what we call a stipulated judgment or a consent judgment. Sometimes they're called pocket judgments, where they will agree to a payment plan over time as long as you grant them a judgment for whatever amount you've agreed on. There's some risk there. I actually put together a whole new tutorial on that very topic. You can see a link down in the notes in the bottom. If you're being sued by Capital One or original creditor, this type of tutorial will help you quite a bit as far as trying to negotiate that. But that's generally the approach that I take, is trying to settle it rather than litigate it. The important thing, though, is to not let it go into default. You don't want to let it go into default, even though your intention is not to go to trial. If you get sued, make sure you file a response to it. Now, one last little thing I want to touch on. I do get the question quite often, what about the strategy of filing a motion to compel arbitration? We talk about that here on the YouTube channel. I have a course specifically on that that's very effective when it comes to debt buyer suits. That is a defense that can work with an original creditor as well. The defense, and if you kind of need to get up to speed, check some of the other videos on my YouTube channel. But the idea is that you can file a motion with the court to dismiss the lawsuit and make the parties go through private arbitration, which they do not want to do just because the costs are so high. That is a good defense. That's a good strategy to use with original creditors as well. Because if you recall, back to our strategy there, we're using the terms and conditions from the original creditor. So it's real easy here. There's no middleman. You can just look right at the terms and conditions, see if there's an arbitration clause. If so, you can seek to enforce that. So I hope that helps if you're dealing with these original creditor lawsuits. They're different beasts altogether. You need to take a different approach generally to trying to resolve them. But again, with a little bit of planning and effort, you can get that done. If you have any questions, go ahead and put them down in the show notes. I always try to watch those or check the comments and respond to those, but I appreciate you watching today.